High Court is given under Article 214 to 232 in Part 6. The first High Court was set up in 1862 in Calcutta, later Madras and Bombay and Madras. The 7th Constitutional Amendment Act of 1956 authorized the Parliament to establish a common High Court for two or more states or UTs. And presently there are 25 High Courts in our country. The constitution doesn't specify the strength of high court and leave it on the discretion of president is given under article 216. Appointment of judge appointment of judges are appointed judges of high court are appointed by the president. The chief justice of high court is appointed with the consultation of CGI and governor of the state. Other judges are appointed with the consultation of chief justice of high court of the state. After third judge case of 1998, the consultation of a collegium of two senior most judges become mandatory is given under article 217. Qualification to be a high court judge is he should be a citizen of India. He should have a judicial office in India for 10 years or have been an advocate of a high court for 10 years. Okay. He take oath before governor is given under article 219. The tenure of high court judge is not fixed and he can hold office during the age of 62 years. He can resign by writing to the president. He can be removed by the president though he through a motion passed by the parliament, passed by the special majority from each house. Transfer of judges is transfer of judges is done by the president with the consultation of CGI and collegium. It is given under article 222. Restriction on practice of a judge after retirement is given under article 220. Okay. Salaries and allowances are determined by the parliament given under article 221. Additional and acting judges can be appointed by the president for temporary period not exceeding 2 years is given under article 224. Acting judges of high court are appointed by the president given in article 223. Jurisdiction and powers of high court under article 225. Jurisdiction and powers of high court given under article 225. Original jurisdiction: matters of will, marriage, divorce, company law, contempt of court. Second, disputes relating to elections of MLA and MP. Third, on revenue matters. Fourth, enforcement of fundamental right. Fifth, civil jurisdiction. Writ jurisdiction and is given under article 226. He can issue writs not only for inside but also for outside of his territory. Also, he can issue writs for enforcement of other laws like constitutional laws and legal laws. So it have wider jurisdiction with respect to Supreme Court. Okay. Um, Now, appellate jurisdiction hears the appeals against the judgment of subordinate courts. Supreme Court supervises jurisdiction, given guides all subordinate courts and tribunals under Article 227. Court of Record under Article 215. Judicial review under Article 13. Transfer of certain cases to High Court under Article 228. Extension of territorial jurisdiction to UT under Article 230. Article 31B saves acts and regulations in ninth schedule from being challenged in Supreme Court. But in 2007, Supreme Court held that via IR Kolhe case, if laws and regulations are violative of Article 14, 15, 19 and 21, or we can say collectively as fundamental rights, are violative of fundamental rights or the basic structure of the constitution, then the blanket immunity will not protect them from being challenged. Okay. And also PIL is outcome of judicial activism and it is taken from USA's constitution. Let's revise writs. First, habeas corpus. We have a body. To have a body. Mandamus, we command. Prohibition, to forbid. Certiorari, to be certified. Q warranto, by what authority? Okay. So these are writs which can be issued by both Supreme Court by Article 32 and High Court by Article 226.